Yes. Please. One is ancestral property. Second one is joint family property. Third one is self-acquired property. All these properties are earned by the joint family members, derived from ancestral, and purchase the property out of income arise out of the joint and ancestral properties purchased in the one of the family member or joint family member, called as the throwing into common stock. That is the word used by our courts, throwing into common stock. Whatever the property purchased in the name of joint family member and it is thrown into common stock, it is also joint family property. And blending into stock, that is the second word. Blending into stock means whatever the property earned by any member of the joint family member, it is throwing into or blending into common stock. So likewise, these are the word used in the property is concerned. Now, what is meant by ancestral property? The forefathers who are earned either by way of grant, either by way of purchase, either by way of Enam abolition under Enam Abolition Act, or service enams rendered by them, those properties are called as ancestral properties. Now, the joint family property means all the joint family members who are earned while they are in joint possession, and it is called as joint family property. Self-acquired property is earned through income arise out of ancestral and joint family property. It is in the name of any members. It is also called as joint family property. Now, these properties, whether comes under for partition or not, that is also question. Now, no family member having any right to dispose of the property by way of will, because these properties are not self-acquired properties. So therefore, based on will, none of the joint family property or ancestral property or self-acquired property purchased arise out of income, family income. These properties shall not be disposed of by way of will or by way of any mode of transfer. So therefore, these transfer can be questioned by way of any member of the family before the civil court. Now, second point, who are the joint family member? Who are the uh, ancestral earned by them? All these persons. So, just propositor of our family who is having so many children, women or men. Now, in those days, one proverb can be used stating that in Kannada, ಕೊಟ್ಟು ಹೆಣ್ಣು ಕುಲಕ್ಕೆ ಹೊರಕ್ಕೆ. These words stating that once she is married, she is not our family member. That type of treatment was made. Then the amendment has been brought in the year 2005, 1/1/2005, which is affected. Every woman of a joint family member, she is entitled equal share along with male person. Now, kottu hennu kulake horake, that type of was ingredients used in the several judgments prior to 2005. So, this fact was brought to notice from our own Honorable High Court of Karnataka. Prakash versus Phulavati case. That is what happened in those cases. Court and korkontare, ಇವರೇನ್ ಮದುವೆ ಆಗುದಿಲ್ವಾ? That is the word has been used. Whether the male person is not going to marry, only female member, why you are using those subjects? So therefore, this type of word used everywhere in India. So for which our own Honorable High Court of Karnataka, under the Lordship Justice Kumar, was dealt this judgment along with in division bench, while sitting in division bench, dealt this matter. Therefore, it is started. Now in that judgment, only two restriction has been mentioned. Those who are not born 1956, before 1956, they are not entitled. That is the restriction has been made in that judgment. Subsequently, it is modified. Vinod Sharma case by Honorable Supreme Court, several decisions were brought throughout India. All the decisions are clubbed together, and Vinod Sharma versus Rakesh Sharma reported in AIR 2020 SC 3717. That is the point was dealt. Every woman of Hindu succession family, as per Hindu succession, they are also entitled by birth itself along with male members. That is the decision was rendered. Vinit Sharma case reported in AIR 2020 SC 3717. So therefore, on that day onwards, all the women started to filing the cases. But while amending the provision of the said act, said section 6 has been brought. What are the ingredients, what are the restriction has been made in that section 6 is, kindly maybe look into, one restriction has been compulsory made by the legislature. Those family members property, either ancestral or joint family or self-acquired property earned through the joint family, those properties are alienated or disposed of, or anything is happened prior to, this is the date, kindly may be introduced to all members of our Hindus. What that is the date which is barred, 2012-2004. That is wherever the properties are disposed of prior to 2012-2004, those properties are not subject matter of partition. So I think you note down all these facts. 2012-2004. That is the restricted made to the women should not claim any partition in respect of property if it is disposed of. So later, point arises between the joint family or ancestral families. So what type of point arose? Whether she is a co-partner or not. She is not a co-partner because she married and living separately. The co-partner should be declared from the 1995. So therefore, co-partner is also required to prove her status as she is joint possession to claim co-partnership. So that is also one of the restrictions. So my request to you, all of you, the partition going to be filed before the court. You have to produce all necessary documents. These are the joint family property. Then you have to file along with the suit, that is inheritance, means the genealogy tree, means Vansha Vraksha, that shall be filed along with the suit. How many members having family members, they shall file the suit for partition of equal share, either male or female members of the family, and that type of suit should be filed. If the partition is declared, by the court. Entitlement of 1/8 share or 1/7 share or 1/9 share. So who is going to be divided? What is the main question? Now judgment has been passed. That judgment called as preliminary decree. That is, the family members are entitled equal share. Preliminary decree. Now, if during the course of evidence, if it is proved any member, this property, particular property is not entitled for partition, because one thing, be aware that Bangalore Development Authority is at Bangalore, and likewise there are several development authorities. Now I, being a employee, I have filed application before the BDA authorities. I am not invested money from the income arise out of family, but that income has been thrown for the allotment of site. So therefore, BDA, I have made an application before the BDA. BDA has executed lease cum sale agreement. Subsequently, sale deed has been executed. It is my personal property. Therefore, the court come to conclusion, whatever the property allotted under the provision of development authority, those properties cannot be treated as joint family property. So therefore, the partition ordered, except the item number 1 or 2, those property which are not earned from the joint family income. So likewise, the dispose of those judgment, that is called as preliminary decree, only identifying they are entitlement of equal share along with male or female members of the family. So then afterwards, what you have to do? Preliminary decree has been passed. It is questionable decree. They are filing the appeal. Appeal, till disposal of the appeal, they cannot divide, they cannot take possession of the property. That is also restriction available in the law. So then automatically, while filing the in appeal there is a order stating that in the appeal, stay will be granted subject to final decree proceeding to be stayed. Subject to final decree means final decree up to what is meant by final decree. Properties shall be divided as per the provision of law, and the division should be in the sealed cover, or it should not be commissioner report, it should not be accepted. So that is the law laid down under section 54 and under order 20 rule 18. The both what it contains, section 54, please note down, section 54 order 20 rule 18 of CPC. These provision, what it says, except the deputy commissioner, nobody is having right to divide the property, to implement the preliminary decree and effect the division and in the final decree proceeding. That is final decree proceeding, the property is going to be divided. So therefore, while dividing the property, there must be a joint family property, all these things, preliminary decree, based on the preliminary decree, final decree going under section 54 and under order 20 rule 18, we are moving the matter, final decree proceeding should be divided the property to us. So therefore, under these provision, if the property divided by the commissioner means deputy commissioner, or he has to delegate the power to the Tahsildar and call for the report for assessment. Assessment means if the share is allotted to A or B, that property shall be assessed. How much tax going to be collected? That is the notified in the RTC if it is agriculture land. Or if the deputy commissioner only managing the revenue records or the agriculture land, What about the house property? House property shall be effected division at the rank of deputy commissioner, who is executive engineer of the concerned jurisdiction. So therefore, house cannot be divided by the deputy commissioner except at the rank of deputy commissioner, executive engineer is having jurisdiction. He shall delegate his subordinate engineer, go and see whether it is divisible or not. So therefore, this fact is also available under section 54 under order 20 rule 18 of CPC. Now, next question arises whether commissioner report can be questioned. Yes, can be questioned. So what type of question it is required? Commissioner report means deputy commissioner accepted the report delegated, which was delegated, and effect the division, put the party into possession, everything is completed. That report is going to be denied by the defendants, by the opposite party. Then he has to make application. I need file objection to the commissioner report. The division was not properly took place. Then, based on that, there is no evidence at all. Based on his oral evidence, it shall be questioned to the commissioner report. Then, if commissioner report is accepted, finality reached. Commissioner report submitted only in the final decree proceeding, not in preliminary decree. So this should be ascertained. This should be mind. You, whatever the commissioner report arise in the final decree proceeding, it is finality reached. Now, another question arose in your mind whether the commissioner report already accepted by the court, the original court who has passed the preliminary decree, who has accepted the commissioner report in final decree proceeding, whether it is appealable. No. No appealable, no appeal can be filed, nothing is available, finality reached. So therefore, everybody, what happened in those days, there are several judgments. Still, this commissioner report affecting the division is questioning before the appellate courts. The appeal is not maintainable. There are several judgments passed by our Honorable High Court and Supreme Court. Once effecting division and put them into possession, matter is end. Now, another question you want to ask me, it is finality reached. Whether house can be effected the division. House on the surface, if it is available, it can be ascertained, it can be allotted by based on the present valuation, market valuation, or real estate valuation. These are the valuations should be collected. Then only this house property can be ascertained to effect the division. And first preference shall be given only the family members if they want to alienate the property. And anybody come forward to purchase the property, that valuation shall be fixed. Real estate price, next market value price, and sub-registrar price. These three prices should be laid down. Then auction sale be called. Under auction sale, it has been sold the property and effecting the division up by way of money. That is house, if it is not possible to effect the division. So these are the provision relating to the property is concerned. So my humble request, you should prepare the partition based on the documentary evidence. Document shall be produced and then get the preliminary decree. Then final decree proceeding shall be filed. Again, in final decree proceeding should be divided the property. Final decree proceeding always section 54 and under order 20 rule 18 of CPC. So you have to take advantage of this provision and get the division of the property, whatever the property of either joint possession or ancestral property or joint family property or self-acquired property earned from the joint family property. Now, recent judgment, I think you have got the information through Google. Recent judgment, Honorable Supreme Court and several other courts passed. Even woman is also Karta of the family because husband died having several children and mother is the wife, means mother of the children is also Karta of the family, has been declared nowadays. If now duties of Karta, it is also one of the lesson for you while examining, while you are attending examination. Karta is having power to alienate the property for legal necessity. If legal necessity is not available, it is whatever alienation made by the Karta, it shall be questioned in any court of law. So therefore, this is also things you should remember in your mind. And partition, how going to be effect. These are the facts available for you. Today, this is the topic for you. Thank you. Any question you please ask me.
Sir, good evening. Thank you for the detailed explanation. I had a very simple question, sir.
Please.
You specifically called out ancestral property,
Yeah.
and you did mention if it is an inam based, and basically if the land has come through inam and stuff, it becomes ancestral, right? And it is
Yeah.
forefathers. You specifically mentioned. I understood that. Now I just want this. Delimitation factor, right? I mean, how do I know that a particular property is an ancestral property or a joint family property? Now, suppose I say for example, right, for a person, his grandfather has bought a property and is managed by, say, is his children, right? And he and the grandfather is actually dies in intestate. Then is that property a joint family property or is it a ancestral property?
Ancestral, because you see, just one head, you should not think that. What happened? One example I am providing you. Now our forefathers are continuously performing their pujas as a pujari. Another person doing some service inam, that is Shanbogi. Likewise, they are having their avocation in the villages. For avocation purpose, the property is allotting to them. And what they are making application before the authority, from forefathers I am continuously cultivating, I am continuously having possession. Therefore, kindly may be. If that word is used, that itself it is a ancestral property. So another one example, every day we are facing problem. Tenancy right under Land Reforms Act section 48A. Tenancy right going to confirm by way of evidence. Application form number 7 we are filing. In form number 7, there is a one column saying that since 50 years cultivating this land, he is aged about only 27 years. How can he say that 50 years? So therefore, such a property is also joint family property. Need not, if grant made in favor of him, still you have to right to claim partition. Likewise, the Inam property, Shanbogi property, service Inam property are all coming from ancestors, not suddenly available. Now we have passed on after lapse of 57 years, 100 years now coming nearly. Now, still you say that, no, 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 there is no ancestor. No, those properties are ancestral properties only. Thank you.
Sir, good evening. I have a very small, question to ask, if it's okay with you.
Please, please.
Now, let's assume a father has bought a property for the son. The son was 19 years old. At the age of 19 years, the father bought a property for the son in the son's name. Now, post-marriage of the son, or right after 30 years, the wife is claiming the property. Does the wife become a legal heir of that particular?
No.
Okay.
Wife cannot be a member of joint family. She is not entitled partition.
So what I'm saying is,
Wife only she can claim maintenance under the provision of CRPC, maintenance under the provision of Adoption and Maintenance Act. All these things available, except she is having right to claim maintenance, not otherwise.
So I thought wife by default becomes the legal heir of a property after it is transferred to the son's name.
No. Automatically, you see, 90. You yourself told me that ancestral comes only our members, blood relatives, not any other person. Blood relative means
ancestral, sir. It is not ancestral. It is a property which was bought in the son's name. Not
whatever. You have to prove then. You have to prove how he has bought. You see, now yesterday one question arose to me. The property has been purchased in the name of wife and minor son. Wife and minor son. Because only son was born, that property was purchased. Subsequently, so many children born. Whether these children entitled for equal partition against minor son which was purchased, because father's income has been invested for purchase of not only wife but also minor son. Such being the case, just to imagine other children born later, but they are all continuously having possession jointly, not only single mother and wife. Now, that is the question arose for me. I have filed the suit against the minor children who has grown up now, against him and mother. Filed suit for partition by the other children who are born later, because it is father's property. Father has purchased the property in the name of family.
Okay. Father has also purchased the property in other children's equally.
No.
So, if
father cannot revoke, sir, once it is alienation, once it is gift has been made, only his right is available now. Present the Senior Citizen and Maintenance Act. Recently it was introduced. If the father is not looked after or mother is not looked after, mother is also entitled to file a case for cancellation of gift or any alienation made, but dispose was made by way of will or anything. Those documents can be questioned in the Senior Citizen Act recently introduced.
So father has filed a partition suit against the widowed wife. So son is no more. So is that valid now, sir?
Sir, widow is concerned, it is self-acquired property of widow. It cannot be thrown into common stock if it is available property in her name. That is example. For maintenance purpose, I am unable to pay money. I am allotting her one of the property, which is joint family property. It is self-acquired property of her, even though it is joint family. It cannot be partitioned. No son cannot claim. No son can claim for partition against widow mother, which was allotted under, even though it is joint family property, allotted for maintenance purpose. It is self-acquired property of her.
Yeah. Second question, sir, if it's okay, if I could ask you, sir.
Yeah.
Now, the wife has, deserted the children. Now, the children have the rights on the ancestral property, as you said, no, sir?
Yeah.
Now, the wife has got numerous properties which are ancestral properties. Is there a wire media to find out which are those properties, sir?
Sir, while recording the Karta in revenue records, they are mentioning how it has been transferred in her name. Under what circumstances it has been transferred. Example for mutation. In RTC, just you go through the mutation. While MR number, that order you should take. And one side, so and so place the document, sale deed, will, or anything. So those documents he has mentioned while he is placing application. Into that effect, the authorities are effecting based on this application, no objection has been claimed by any other family, therefore effected the mutation. But does not mean that having mutation or having Karta in their name, he is not absolute owner. Karta does not going to fix their title to the property. Only the registered document, if it is available, then the title can be claimed, not by Karta, not by tax.
Thank you, sir. One clarification here.
Please.
If an ancestor property which is in court because of the differences and waiting for judgment, the judgment is still to come, can the parties do a settlement or not settlement, really a partition outside of the court?
Not outside the court. During pendency of the suit, they can place outside the court only by way of registered document. Registered document means partition. That is only document is available for get it registered by all the parties to the proceeding who are entitled to claim their effect of partition.
Okay. But even though that is in court, still the parties can do a partition or registration.
Registration can be done, and that registration document shall be placed with memo and permit us to withdraw. That's all. Matter is ended with registered document.
Okay. Thank you, sir.
Welcome, sir.
Hi, sir. So is the will to be registered or even unregistered will can be done?
Sir, Hindu concern, it need not be registered. It can be registered because why the peoples are intending to register means safety purpose. That's all. And one thing note down, please, today onwards you must tell anybody else, you should like this, will pertaining to agricultural land, probate must be get for getting document in their name in revenue records. It must be get probate. Beneficiary should get probate. This is division. This is full bench of our own Honorable High Court of Karnataka. It was decided will is not a document. Will is not going to confirm title to the agricultural land. Therefore, probate should be obtained from the civil judge court. Then that probate order shall be placed before the revenue authority. Then Karta will be affected. Directly based on the will, it cannot be affected.
Thank you, sir.
Welcome.
So you're telling basically based on the current judgment of the Honorable High Court, if you have an agricultural land, it is best to gift it rather than will it?
No, it is best gift because Section 128 of Karnataka Revenue Act, will is not described. Gift, sale, inheritance. These are the word used. Section 128 of Karnataka Land Revenue Act. What are the documents required for mutation, effect of mutation or Karta?
So this particular, okay, you specifically called out the Karnataka Land Revenue Act, but this particular decision, judgment given by the Honorable High Court of Karnataka.
No, it is confirmed by Honorable Supreme Court also. Everywhere the law is available for agricultural land, will shall be placed only before civil court to get probate. Throughout India it is available, it is applicable law because it is full bench judgment.
Thank you, sir. That clarifies.
Welcome. No ladies are asking any question. Nobody is there. Because Vinod Sharma case, it is landmark judgment. And one thing in that judgment, one decision was taken stating that Pan Parikat or partition took place, unregistered partition took place. And those documents are concerned. They have to prove unregistered document by way of partition was took place, that is under oral partition. Therefore, we have already arrangement has been made and we are enjoying our portion of property, they can say. That means unregistered document, unbelievable. It is based on evidence only. It shall be proved whether partition was took place or not. Because today everybody is making to effect the division in favor of female members of the family. And those documents are created for 1976, 1978, 1992, 2003, 2000. Likewise, they are making unregistered partition. So those subject matter of evidence only. That is another word called as pan parikat.
Sir, you specifically spoke about this particular year 1956 born, and
Yeah.
then later you told 2012-2004.
Yeah, that is Supreme Court has passed Vinit Sharma's case, clarify the matter. Whole that is judgment about 20 pages available, recent judgment. Because that is the word has been used in that judgment, stating that 2012-2004, which is restricted, but by birth woman is entitled. Because in earlier case, Fulabati versus Prakash case, it is only 1956. Later, they are entitled for partition. So therefore, it has been clarified because the enactment says it is by birth only.
So if a female child is born after 1956 and they have male members in the family, in the family along with the Karta, and they have divided and registered in the mutated records for the male members, does the female have any chance to go ahead and file a case?
No, sir. What just you cut off date? I have given cut off date 2012-2004. Okay. You have to claim if prior to this date, if it is disposed of by way of partition, by way of sale, or any arrangement made which is registered document is available, automatically the female member is not entitled.
Okay, sir. One last question, sir, especially with respect to joint family property. Yeah. Is possession a problem?
Possession?
Is possession of the property a problem? Because it is within the family.
Within the family, if arrangement has been made, they have got it divided and possession has been delivered. No, you can't say that possession is not available to them.
Okay, sir. Let's take a simple example where there is a property and it is in joint possession along with say 1, 2, and 3 properties. But fraudulently, if one of them has mutated the records for one of the property X, right? And over a period of whatever, say for example 40 years, and later can we go and claim that particular property because
Sir,
we are not aware of it?
Mere having mutation, mere having Karta, it is Justice Gopal Gowda judgment of our own Honorable High Court of Karnataka. The title is not going to confirm. While sitting in Supreme Court also, the same word has been used by Lordship Justice Gopal Gowda ji. So therefore, mutation, Karta, continuously having all these things gone. It cannot be said that title is going to confirm on him because he is having joint family property in possession by virtue of mutation. You see, one example I am providing you. Every person coming before us saying that Kata should be transferred in a single person's name because we are enjoying all of them. We have no objection and we are preparing affidavit into that effect. We know that the mere changing the Karta, he is not the owner. So therefore, automatically having Karta, having the tax paying, all these things, only the private properties against any other person's private property, not under the joint family properties. And one thing I want to tell you, for example, 12 years private person enjoying the property against the private property, it is 12 years is sufficient to prove that 12 years adverse possession. And if we want to prove against the government property, 30 years limitation. These are the two conditions: are private property and the government property.
It is not applicable to joint family property.
No. It cannot be.
Yes, sir. Thank you. Thank you so much.
Welcome. Thank you. If any more judgments, one Danamma's case is also delivered by our own Honorable High Court of Karnataka by division bench for partition. And Vinod Sharma's case is also applicable for the same thing. It is also good judgment. And Vinod Sharma case is also referred Danamma's case. And anyone, any questions, please ask me. Madam Bharti, you have not asked because it is your case today. And somebody's are there. Yes.
Okay. So if a person is above 60 and if he's doing a gift deed, is it still valid? And even if the family members are not known, but
he need not, even if it is self-acquired property, only he is executing, not for joint family property. And one thing I want to tell you, if will is also going to execute by Karta of the family, affecting the division among the family members. If unequal, he can question. If I am going to bequeathing the property by way of will, equal division I am going to make out from my joint family property. So if it is ascertained by other people, and it can be accepted by the court, equal partition available, all the family members got by way of will. Yes, Karta of the family having right to effect the division by way of will also.
Okay. So if it is example, if it's a self-acquired property and they execute this will, they execute this gift deed, but their family members would not be aware. In that situation, can their family members go ahead?
Sir, one word proverb is there: self-acquired property, to anybody can enjoy it because it is his right. Somebody is looking after him. He is going to gift away property to them. No problem for him. That property should be available to our family. No. If I am having self-acquired property, I can gift away to anybody else, not only family members.
And when you told Senior Citizenship Act, right?
Say, senior citizen, what for? You see, why it is, I am saying, if gift deed has been executed to somebody, he is going to look after me. That word with love and affection, and future my all obsequies going to be done by him. So therefore, I am under love and affection executing the will to A, who is not at all relative. But tomorrow, if he has not rendered, or if he has not look after me, I can ask for cancellation of that gift deed because it is self-property of mine.
Sir, I have one doubt, sir.
Yeah, please.
Yeah, sir. If the while acquiring self property, an individual, if he uses some amount of the HUF, share.
Yeah.
So can he
You have to
divide?
prove. You have to prove. You see, one example I am providing. I have purchased the property. I went to my village, and I have also received some amount from the
Yes, some
earning of
coconut
other joint
ancestral
family,
garden.
other
Yes,
joint
same.
family property. I have
Correct.
purchased in my name. Then
Yes.
whatever amount I have received, that accrues that it is also one of the joint family property. We have to prove based on the documents.
Even a small portion is amount is taken from the
Whatever it
joint
may
family
be,
income.
if you have taken single pie, it is
Okay.
also amounts to a joint family property only.
So that cannot be given as a will to
No.
anybody.
And one thing, section 123 is very clear. Transfer of Property Act, gift shall be registered. That is starting word itself, it is registered.
Yes. Okay.
Good evening, sir.
Very good evening, madam. Just I am asking you. Nobody has come forward to claim because right has been confirmed on you, but still you don't want to question to me. Yes.
No, sir. Just going through because for me it's a bit of new subject. I had no much of idea.
Right
Well,
now.
I have a question. Sir, could you please explain and brief about the minor's right about the family property and if they have any objection to the sale?
Only one word is available, madam. In Hindu law is available. Womb in the child. As on the date partition going to be took place. If the child is in the womb, having equal right along with others, madam. That is the word available in Hindu law. Womb in the child is also entitled equal say.
Fine, sir. Thank you.
Welcome. Shall I close now?
Yes, sir. Thank you.
Thank you. All of you, thank you. Good night. Good day.
Thank you, sir.
Yeah, thanks for the exclusive explanation from your side, sir.
Thank you. Thank you.
Thank you, sir.
Thank you.
Correct ಬಂತ ಎಲ್ಲ ಇನ್ನೇನ್ ಬೇಕು ಅದಕ್ಕೆ